If Mary McGee was the most famous litigant in Irish constitutional law in the 1970s, the Skerries woman who challenged the constitutionality of the legislation prohibiting contraception, Gladys Ryan was, I think, surely the most prominent constitutional litigant of the 1960s, the Drumcondra woman who challenged the constitutionality of an obscure piece of legislation called the Fluoridation of Public Water Supplies Act of 1960. So this was a piece of legislation enacted by a Fianna Fáil-led government which required local authorities to put fluoride in the public water supply. The science indicated that this would be good for public health, for dental health specifically. Gladys Ryan objected. She was a mother of 5 children and felt that this was something she did not want in her body or in the bodies of her children. She challenges the constitutionality, ultimately loses the case because really of the proportionality concept, that this was, the science suggested, the evidence was very much good for public health and came at very little, if any, cost to individual health, and so was not unconstitutional. So why is the case famous? I mean, it's such an obscure context. She ultimately loses. Why is the case famous? Well, because it brought about the unenumerated rights doctrine in Irish constitutional law, which really is, in simple terms, a doctrine that holds that there are rights that are protected by the Irish Constitution that are not expressed within, that are not enumerated by the text of the Irish Constitution. Implied rights doctrine, if you will, or the derived rights doctrine, but has always been and continues to be for the moment referred to as the unenumerated rights doctrine. Certainly the place to start in analysing this case is Article 40, a pretty lengthy article of the Irish Constitution protecting personal rights. And here really you should cast a very careful eye on 40 section 3 subsection 1, read in conjunction with 40 section 3 subsection 2. So just take your time running your eye over the phrases used in the 2 subsections I mentioned. Now, probably for clarity, what you could do is to remove lots of the words in those rather wordy provisions and just read it as follows. The state guarantees to defend and vindicate the personal rights of the citizen. And then in the following subsection, the state shall in particular vindicate these 4 rights. So I guess Gladys Ryan, in the circumstances of the water fluoridation case, had a sense that, this was invading her bodily autonomy, her own control over her own body, that this was invading, if you like, her bodily integrity. There was no express right to bodily integrity in the Irish Constitution or bodily autonomy, call it what you will. So her lawyer, Sean McBride, seized upon this wording and argued, look, he said, obviously the implication of the way in which Article 40 Section 3 is articulated suggests very much that there are rights other than these 4 that enjoy constitutional protection, and bodily integrity, he said, was one of them. And the judge, Mr. Justice John Kenny, in the High Court essentially agreed with him. Now, the trouble with the judgment in the High Court is that it's terribly long, more than 60 pages, I think, and really for our purposes, I think you need only a chunk of it, 6 or 8 pages, so roughly pages 311 to 315, 16 or thereabouts, where he talks about his justifications for identifying the right to bodily integrity as among those rights that aren't just moral rights, but rather have this constitutional status. So the first ground or justification, he has 3. The first is the text itself, which we've just talked about. He says, well, look, if you read this text of the 43.1 combined with 43.2, the strong implication is that there are rights other than the 4 that are expressed that enjoy this status. That's fine so far as it goes. Of course, it doesn't tell us that the right to bodily integrity is one among them, but it's fine so far as it goes, and it's hard to argue with. The second and third grounds are really, I suppose, kind of remarkable, I think it's fair to say. So the second, he says, rights that can be said to flow from, quote, the Christian and democratic nature of the state. Now, what right that you might care to think of couldn't be thought to, quote, flow from the Christian and democratic nature of the state? Right, so he cites the right to travel freely within the state, not at all controversial. The right to marry, not at all controversial. Fine, but he seems to think the right to bodily integrity, of course, similarly flows, which I guess it probably does. But what doesn't flow from the Christian and democratic nature of the state? And then the third ground, maybe even more remarkable still, insofar as Justice Kenny, Mr. Justice Kenny in the High Court, identifies, or if you like, relies upon the papal encyclical Pacem in Terris, Peace on Earth, that had been enunciated by the Vatican a month or two previously, which had identified the right to bodily integrity as among the rights owing to man in virtue of his humanity. In other words, as a natural right of man. In respect of the particular case itself, I guess the conclusion was, yes, there's a right to bodily integrity, but no, it's not breached in the particular case. That was what the High Court decided, and on appeal to the Supreme Court agreed. Yes, a right to bodily integrity. No, it wasn't breached. The language of proportionality wasn't used, because I guess that language hadn't come into vogue yet in Irish constitutional law. In fact, it didn't for another 3 decades. But the concept of proportionality was used. In other words, the court concluded that, or was satisfied on the evidence that this brought about great advantages so far as public health was concerned, at no cost, or little or no cost, to individual health, as it were. In particular, if we focus on the third justification provided by Mr. Justice Kenny, right, the Pacem in Terris justification, it effectively concludes that we can move from the ought to the is in Irish constitutional law. In other words, that a judge in the High Court can say, look, right X ought to be a right that has legal status under the Irish Constitution. Therefore, right X has legal status under the Irish Constitution, which is really problematic from the point of view of democratic legitimacy. You could say the same, to some extent, about the second justification, right? Rights flowing from the Christian and democratic nature of the state, particularly insofar as Mr. Justice Kenny doesn't actually, in his judgment, connect the dots, in the sense that he doesn't actually show how this has some grounding in the text and structure of the Irish Constitution, which it surely does, insofar as the Irish Constitution envisages certainly a democratic state, if not a Christian democratic state. Now, if you think about the hullabaloo generated by constitutional amendments, I mean, effectively, what are judges doing here in these cases when they identify a right to seek work, for instance, as Mr. Justice Donald O'Donnell did himself in NHV and the Minister for Justice? If they identify a right to marry, a right to know the identity of one's birth parent, for instance, or whatever it might be, in a sense, you could argue that they are amending the text of the Irish Constitution. Not quite, but arguably. And if you think then in the context of the famous referendums that we have these days pretty regularly, and the kind of heat that's generated by the political contestation around whether this wording or that phrase should be in the Constitution or not, then this really does seem to vest enormous political power in judges. The case itself has not been subjected to a great deal of criticism. John Morris Kelly, Professor John Morris Kelly, he of the Kelly on the Constitution fame, was among its early critics. He made the point that, look, there were rights along these lines, bodily integrity, set out in Article 45 of the Constitution, but expressly, by the terms of Article 45, deemed to be non-justiciable, not the business of judges. And yet here were judges like Mr. Justice Kenny and others in later cases bringing in rights like this through, as it were, the back door. See, but other than Kelly, on the whole, the rights were popular. The cases were not controversial all that much. For instance, Irish judges identified a right to marital privacy, of course, in the Mary McGee case in the 70s, to privacy, to communicate, and other such rights. In other words, judges didn't tend to go off the reservation, as it were. They identified rights that were broadly in keeping with the spirit, if you like, of the Irish Constitution. And so this hasn't been, wildly controversial or unpopular, whatever. Mr. Justice Donald O'Donnell of the current Supreme Court makes that point in one of the better pieces of writing on this case, Sleep of Reason, from a 2017 issue of the Dublin University Law Journal. Gerard Hogan is another of the contemporary judiciary who criticises this judgment. Ryan, the Attorney General, Gerard Hogan says it's in the book I co-edited myself, it's in Judges, Politics and the Irish Constitution. Gerard Hogan has a good chapter in that book on this case. He kind of says, look, it deflects attention away from the actual text of the Irish Constitution. He says the right to bodily integrity could effectively have been identified as a right flowing from the right of the person in Article 40, Section 3, expressly in Article 40, Section 3 itself. And he goes on to cite other examples of how judges didn't need to go there, as it were. They didn't need to go off the constitutional terrain to find the results they wanted to find in particular cases. It was closed off effectively in mid-1990s in a case judgment by Mr. Justice Roland Keane at the time, where for the last time a new right was identified that hadn't previously been identified. And there are signs of life now, right? So NHV and the Minister for Justice is probably the most prominent, the right to seek work, but there are others. In the High Court, for instance, the right of access to third level education, for instance, Mr. Justice Richard Humphreys in the High Court in the Rebecca Carter case identified that right but was overruled in the Supreme Court. Similarly, Mr. Justice Max Barrett in cases concerning environmental activists, the right to a good environment, basically, or a right to an environment consistent with human dignity. Now, there is a judgment handed down in 2020, I think, written by the Chief Justice Frank Clark, Friends of the Irish Environment versus the Government of Ireland, where Mr. Justice Clark talks in very interesting ways about the unenumerated rights doctrine, suggesting that it ought to be repackaged as the derived rights doctrine. Now, my good friend David Kenny tells me recently that Mr. Justice John McManamon, also of the Irish Supreme Court, had been talking about this in some jurisprudence over the last few years, but now it's kind of coming to fruition. And Frank Clark's point really is this: a derived rights doctrine would make it clearer that the rights that judges could identify would be, as it were, not expressed, but derived from the text and structure of the Constitution. Whereas the unenumerated rights doctrine implies that there's no need for there to be a kind of a connection between the new right and the text and structure of the Constitution. So in other words, it's a more reined in, civilized, if you like, version of the unenumerated rights doctrine. I think there's great merit in that.